Over the past few decades, Congress has passed or amended several federal statutes to prohibit discrimination against and protect the rights of people with disabilities. Some of these laws, such as the Americans with Disabilities Act, or ADA, and the Rehabilitation Act, require employers to provide reasonable accommodations to employees with disabilities. In Lyons v. Legal Aid Society, the Second Circuit considered whether an employee's request for an accommodation may be unreasonable as a matter of law. Beth Lyons was a staff attorney at the Legal Aid Society in New York City. In 1989, Lyons was struck by a car and sustained near-fatal injuries. As a result, Lyons took several years of disability leave, during which she underwent extensive surgeries and physical therapy. In 1993, Lyons was ready to return to work, but couldn't walk long distances or stand for long periods of time. Therefore, Lyons asked legal aid to accommodate her disability by paying for a parking space close to work. Lyons's doctor confirmed that Lyons required a parking space to return to work, but legal aid refused. Lyons ultimately returned to work and paid for a parking space herself. Lyons filed suit, claiming that legal aid failed to accommodate her disability in violation of the ADA and Rehabilitation Act. The district court dismissed Lyons's complaint for failure to state a claim, finding that Lyons's accommodation request was unreasonable as a matter of law. Lyons appealed to the United States Court of Appeals for the Second Circuit. She argued that whether her request was reasonable was a question of fact, and thus that the district court couldn't decide reasonableness as a matter of law without first developing a record and conducting discovery.